Just to start off, I want to recognise that the Aboriginal and Torres Strait Islander people are the first peoples of Australia. We are meeting on the traditional lands of the Kaurna people, and we pay our respects to the Kaurna people and their elders past, present and emerging. So just a bit of background. Return to Work SA is governed by the Return to Work Act, as well as the regulations and subject to the impairment assessment guidelines as well. Together, these provide the framework for the scheme to operate within. Something that I think is worth mentioning, because a lot of people don't actually realise this, but Return to Work SA is not a government-funded body, and we don't receive any funding from the SA government. We, as a scheme, are funded through the insurance premiums that are paid for by SA businesses, the employers of the state who are registered with us, as opposed to the self-insured employers. And then our aims. One of our core aims is to deliver appropriate, timely and effective services in the event of a work injury. So what do you get if you have an accepted claim, or what are your entitlements? If your claim is accepted and you have lost time from work, you have up to 104 weeks of income support. You also have 12 months of medical expenses. Now, there's a note here about prescribed classes of injury can apply for ongoing medical entitlements. Silicosis or pneumoconiosis, including silicosis, is a prescribed class of injury. What that means and why it's relevant is somebody may present with silicosis but need to have treatment for a very long time, or they may have very few current medical needs, and those medical needs will become more apparent down the track in many years to come. So there is the ability within our Act that they can apply for their medical expenses to be provided for ongoing beyond that 12-month period, and they can do so by contacting the specific team within Return to Work SA who are responsible for managing the silicosis claims. It's also obviously going to be quite important if at the time when your patient is diagnosed and they lodge a claim with us, they may not currently have capacity for work, and that might be something that comes down the track. In addition to that, there's also the provisions for serious injuries. So if they have a whole person impairment that is at 35% impairment or above, then they have ongoing support for income support until they reach retirement age, and ongoing medical support for life. In the event that they're not able to have that assessment, there's also the ability for them to apply to be treated as seriously injured on an interim basis. And there is a process that we go through in assessing their likely impairment, whether they are likely to reach that level. And then the lump sum of money that is available is once the whole person impairment process is completed, and that's set on a scale that's your level of impairment and your date of injury. That goes into calculating what that is. Now, I just popped a screenshot of a page on our website that provides support and information in relation to silicosis. So you've heard us mentioned about a phone number to contact. We have a dedicated line, and it takes you straight through to the team who investigate and manage the silicosis claims, which, if anyone wants to note it down, is 8233 2545. We also have an email address that will take you, it's a specific email address that's monitored by the same team, which is just silicosis@rtwsa.com. The page that we've got with information also has a section just on the right under related links, silicosis for medical practitioners. So it provides some information that's more specific to yourselves as doctors. The main page is aimed at people who have been exposed to silica and maybe looking at making a claim as an injured worker. A lot of the information crosses over, but it's a useful resource if you are not sure where else to go. And yes, the team who look after it is our enable team. So they also look after our catastrophic injuries and are managed in-house at Return to Work SA. So what is required to substantiate a claim? I go through a little bit of what is actually needed in order for us to investigate and determine a claim for compensation. So in order to lodge a claim, there's a couple of things that need to be met. The worker needs to have incurred a loss. Now, that loss might be loss of income, if they're no longer working, but it may also be if they have needed to take some time off in order to attend some medical consults. It doesn't need to be a case of they've quit their job for it to be considered a loss of income. If they've incurred any medical expenses, so if the screening's been covered, they may not have incurred those expenses, but they may come through in another avenue. And so those medical expenses are a loss that we would consider for that compensation, and it's something to be determined. Or if they're far enough along and they're considered to have a permanent impairment, that's also a loss. I suppose the important thing to capture here is they don't need to have an impairment or a permanent impairment in order to claim. That's one of the components, but it's not the only prerequisite in order to lodge a claim. The worker must have the intent to claim the compensation. So under the ReturnToWorkSA Act, nobody can force the worker to lodge a claim. They may decide themselves that it's not something that they want to do, or it's not something they want to do yet. If that's the case, we can capture the information that's provided to us and we list it under a notification, and then it just sits there in the background. If they ever want to come back, they can do so and we can progress it as a claim. But unless the person decides that they want to progress their claim, it won't be a claim for compensation. And then there is some minimum mandatory information that needs to be provided. Most of this will be from the person lodging the claim, but there is some minimum mandatory information that is required from their doctor, which will be relevant in order to be able to progress it. So this is just an excerpt from our Act under Section 30, which specifies what we need from the doctor. So the certificate in a designated format, that's the work capacity certificate. And it needs to specify the nature of the injury, probable cause, if they have an incapacity for work, and what their current and future incapacity is likely to be. Which again comes back to that point of they might still be working, they might still want to continue working, and you may feel a bit stumped as to what could that incapacity be. It could be a short period of time that they've had off to attend an appointment, or it could be a case of if they've been working in a dusty environment and they have a diagnosis of silicosis, working in a dusty environment is no longer what is recommended for them. They may not be able to work in that workplace anymore or in that line of work anymore, but they may still have the physical capacity to work in any other type of work. That's still an incapacity that we would that would qualify for a consideration for a claim and a determination under our Act. And in the event that they are in a situation where they are looking at having to change workplaces or change types of employment, that's something that we can provide support with. So we can support them in identifying alternative parts of employment, whatever retraining may be required in that space, and assist them in that process, funding to do so, etc. Now, because silicosis can be something that they have been exposed to over a period of time, it generally falls under our injuries that develop gradually, which is Section 188 of our Act. In relation to injuries that develop gradually, the incapacity is the date of injury is taken to have occurred when the person becomes wholly or partially incapacitated for work. I've mentioned it a couple of times, but if they can no longer work in that environment, they need time off to attend a medical appointment. Those sorts of things can cover incapacity, as well as the obvious, they're short of breath, physically can't continue doing work, need to go down to part-time or something like that. The other element that is worth being aware of that our Act covers is the presumptive legislation. So under Section 9, it states that if a person is suffering from a particular type of injury and they've worked in a particular type of work, instead of needing to prove that their injury occurred in employment, the presumption is that employment caused their injury. And the onus of proof is then switched around to be the opposite. So then it's more a case of, or it is a case of having to prove that their employment did not cause the injury that they had. Silicosis is now covered under that, and the types of employment is mining, quarrying, cutting, crushing, grinding or pushing stone, or melting, grinding or polishing metal as currently specified in our Act. That doesn't mean that if you're working if they're working in another type of industry where they've been exposed to silica, that they can't lodge a claim or their claim won't be accepted. It just means that the evidence that's gathered is a little bit more, because it's the standard approach of needing to prove that employment caused your injury, rather than the assumption that employment was the cause of the injury. So for this reason, a diagnosis is obviously very beneficial if there is a formal diagnosis of silicosis, because it switches that burden of proof and can make it easier and quicker in determining the actual claim because of the types of evidence that needs to be gathered. So just a bit on the investigations that we go through when a claim is lodged. So the depth of the investigation, it's very dependent on the circumstance of the claim and the nature of injury. But for the most part, so this list here is the types of things that we would generally look for in a silicosis claim. If they do have a treating GP, then reports and history from the treating GP is always going to be useful, or a treating specialist. That can be particularly useful in capturing any history and etiology, which can then also be useful for determining if they've worked in multiple employers that are capable of or that have caused exposure, where that exposure first started from. A lung function test is useful both from the diagnosis perspective, of course, but also from a claim determination and ongoing management perspective, because it can help us to determine the progression of the disease, or that yourselves, the doctors, to determine the progression of disease. It's useful in our determination of what level of support they need. And if pre-employment medicals have been conducted, they can be useful for the same reasons in capturing that history and when it first appeared. The factual investigations, we often use these in silicosis because, particularly where workers have worked in the industry for many years across many employers, it can be difficult for them to think back, when did I first work somewhere where I was exposed to silicosis? So rather than needing to rely on whatever they've noted down and provided to us, we can utilise a factual investigator to capture that information in a greater depth of detail, which also captures their employment history, exposure history, and can help identify what other employer documentation we need. This is more about determining the specific employer for exposure that the claim will be lodged against, noting that if they already have a diagnosis of silicosis, then the assumption is that their employment has caused the injury. So it's less about determining whether the injury will be accepted and more so where it belongs against. Then when it goes into a determination of a claim, there are 4 eligibility tests. Now, this is standard across all types of injury. It's not specific to silicosis, but we need to determine whether or not they are a worker under the Act. So while it can look like from the outset very obvious that they were working, they may not be covered by the Act definitions as a worker. So some self-employed workers or subcontractors are not necessarily provided cover under the registered scheme. This is something that we need in order to determine their claim. And unfortunately, it can mean that somebody could have a diagnosis but not meet the test in this area. But it is one of the things that we need to cover off on. The next one, an obvious one, is there an injury or illness? What's relevant here is sometimes we will receive a claim that lists symptoms rather than an actual diagnosis. A person with symptoms doesn't give us enough to be able to determine an injury that is able to claim compensation under our scheme. So a diagnosis is necessary. Obviously, if that can be provided before the claim is lodged, it makes things a lot quicker and easier, but we can assist throughout the determination process in seeking to find what the actual diagnosis is. But of course, it's not necessarily clear that it's going to be silicosis because there are a number of other types of things it could be instead. Then the next one, is there a connection to employment? So we need to understand the specific connection to employment and also the specific employer that it is linked to. This is where the detailed employment history is required to be able to establish that connection, as well as a detailed list of their duties and types of exposure, which is particularly helpful when we're talking about multiple places of employment, to determine where that exposure is likely to have occurred for the purpose of the injury, but also is it sufficient to have been the cause of their silicosis right from the outset in this investigation and determination process. And then the last point is whether any exclusions apply. For the most part, this isn't really going to be relevant for silicosis. There are some additional exclusions for psychological claims, serious and willful misconduct and things like that. But generally for silicosis, we don't see these as particularly relevant, but it is one of the tests. And then when it comes to actually determining the claim, we do rely upon all of the evidence that's gathered. So particularly when we're in a situation where you might have evidence that looks conflicting, or it tells multiple different stories, it's useful to have as much as possible that you can provide or assist in the provision of, because that then helps to determine what weight is given to the evidence that we've got. The medical certificates, medical history, medical reports that you provide are critical to this determination. And while specialist medical opinion is often required, is very often required for silicosis, the information from a treating doctor is more likely to capture the historical progression of the injury, particularly if you are a family doctor or have been seeing this patient over a period of time. A specialist IME who sees somebody once captures a history, but it's the worker's version, the injured person's version, what they can recall. And, you know, if we're going back far enough, it's very difficult to capture that in enough detail. Then when it comes to the point when we've got all the evidence in order to make a decision, we'll call the person who's lodged a claim outlining what the proposed decision will be and give them and their employer the opportunity to provide further information. This is going to be particularly useful if we don't have enough to be able to accept the claim, and there may be more information that they're in a position to provide, as an example. And then following that, when it's clear that there is no further information to be provided, we've got everything that we need to determine it, we'll issue a formal decision letter that outlines the reasons for the decision, whether it has been accepted or rejected, and what it has been accepted for in the event that it is accepted. And that is everything from me.